Hello, welcome to CSC 239, Cyber Law and Ethics. Today we're going to be talking about the United States of America's federal laws that govern the Internet. So before we get into the specifics of what America does, we're going to look at some of the issues that we see in other countries. In the United States itself, it limits the access to online pornography. And, you can argue that's a good thing, you can argue that's a bad thing, and we'll be discussing that in a heck of a lot more detail as we move through this PowerPoint. France and Germany, they limit hate speech. If you know anything about World War II and the historical context, German leader Adolf Hitler was not a big fan of Jews, gypsies, political prisoners, homosexuals, intellectuals, all those people. And he basically tried to kill them all. So the hate speech is largely directed from what happened in the 1930s and 40s in Germany, and then when Germany invaded France. So, there's a very specific reason for that. China, they suppress anything negative said against the government. China is an authoritarian country with a very powerful leader, and as such, they get to decide what can and can't be said about the government. It's not a democracy. So, the first question we want to ask ourselves is online suppression wrong? The question really is, what is appropriate free expression for organizations and individuals on the internet? A major complication is the social implications that arise when local governments seek to regulate content based on ideology. That being, a political perspective or a viewpoint. On the one hand, there is the Constitution, which states we have free speech. But on the other hand, local communities get to decide what is obscene or not. So what may be considered obscene in Kansas may not be seen as obscene in California. And herein lies the issues that we are going to be looking at throughout this presentation is the rules that govern the United States in terms of our Constitution oftentimes don't give us black and white answers. You have to find the answers in between those lines. So let's start off with pornography. Child pornography is illegal under all circumstances. It's never legal. According to some estimates, the internet has 100,000 sites that offer child pornography, which is a pretty staggering number of websites. Obscene speech is defined by community standards, and it is not protected by the First Amendment. So if a community deems something obscene, it is considered to be inappropriate and not part of free speech. So when is speech obscene? In Miller v. California in 1973, the Supreme Court established a three-part test to determine if speech is obscene. And Miller was an owner of a California mail-order business specializing in pornographic films and books, and they sent brochures to unsuspecting families. So basically the question is, if you get a catalog in the mail, I know most of us only get stuff through our spam email, but in the 1970s, if you got a catalog for pornographic materials, is that obscene? So, the Supreme Court has a three-part test. Number one, does it depict sexual or excretory acts explicitly prohibited by state law? Excretory means pooping, someone pooping on somebody else, somebody doing other poopy things. Number two, it appeals to prurient interests as judged by a reasonable person using community standards. Meaning it's not erotic as much as just tawdry kind of thing. And number 3, it has no serious literary, artistic, social, political, or scientific value. Over the past 150 years, various books have been called obscene for various reasons. For example, The Color Purple, because it featured domestic violence and sexual violence, was considered obscene. But it was also an award-winning book that had a serious impact on literature and the way we view the African American experience in the United States. So, as people who value culture, we also have to look at, does this bring a certain level of cultural importance to the forefront? And again, so many books have been argued that are obscene. Everything from Huckleberry Finn by Mark Twain all the way to the Bible in many cases. There's been a movement to censor parts of the Bible that they don't feel as appropriate. There are various and sundry issues. Go back to the Old Testament and you have Abraham who has no children, so his wife invites him to have sex with her handmaiden to have a child. Therein is adultery in a sense. So again, a lot of this is based on how we view culture. Children are a special case. In the case of Ginsburg versus New York, the court identified certain speech is not obscene for adults, but it is harmful to minors, and minors are 17 or younger. This includes a prurient focus on nudity, sexual conduct, sadomasochistic abuse, and that's, whips and chains and all that kind of good stuff. So when we look at obscene speech, we're only looking at it from the perspective of adults. And anything that's directed towards kids needs to avoid those 3 biggies. No, violence is not on there. Apparently violence is fine for kids. So there's been 3 major attempts in the United States to regulate the internet. The Communications Decency Act of 1996, the Child Online Protection Act of 1998, and the Children's Internet Protection Act of 2000. This all occurred within 4 years because the internet first became commercially available to individuals in 1995. So this cascade of laws came about because people just didn't know how to manage this new technology. So let's start with the Communications Decency Act of 1996. The Communications Decency Act imposed criminal sanctions on anyone who knowingly uses a computer service to send obscene or indecent or pornographic material to a person or persons under the age of 18. Also, it imposes criminal sanctions on anyone who knowingly uses any computer service to display obscene or indecent material or pornography to a person under 18 years of age. It further criminalized the transmission of materials that were obscene or indecent known to be under 18. So essentially we're going to protect our little babies to make sure that they don't see any boobies. Well, the reaction was swift and loud and very, very critical. Critics claimed the bill would have a chilling effect on the availability of medical information and prevent people from finding information out about sexual education. Others claimed it violated free speech. Others worried that it would limit the availability of art and literature. And additionally, the act could not control sexual content that came from other countries. Keeping in mind that we have had congressmen and senators who have tried to declare certain artworks as inappropriate for public consumption because you see a woman's breasts or buttocks or a man's butt or chest. They even went to one extent where one of the congressmen, and I forget who it is, but wanted to put a shirt on one of the sculptures that's in the White House or in the congressional buildings. So you can see why people were a little freaked out. The other thing that really gets into if you are a 14-year-old boy or girl and you have questions about sex and you don't feel comfortable talking to your mom and dad about it because they don't seem to be interested in discussing it with you, the easiest thing in the world to do is go on the internet. And the reality is that's where a lot of kids these days are getting their information about sex. In certain parts of the country where sex education is either inadequate or not taught at all, this might be the only resource for some kids. And consequently, the law was appealed. Dun dun dun! The court case became known as the ACLU versus Reno. The 1997 law was struck down by the Supreme Court as violating the First Amendment and the Fifth Amendment for due process. And again, this has been an argument that's been in place literally since the advent of the internet in the mid-90s. What is allowed or not allowed? The Supreme Court decided that their decision emphasized the restriction of content for minors actually suppresses the constitutional rights of adults. The court assumed that an internet user has to actively seek out inappropriate material on the internet, whereas inappropriate material on TV or radio is more likely accidentally viewed or heard by minors. So your average 4-year-old probably not going to be able to type, porn into the computer, but, take your average 14-year-old and they certainly know how to spell that. So, in a sense, what the Supreme Court is saying is that if you're willingly engaging in this, that's your parents' problem. It's not the state or the federal government's issue. So then we moved on to the Child Online Protection Act of 1998. This law would make it illegal for people who ran websites to make sexually explicit materials available to minors. Websites have to collect credit card information before they would let a user into their site. This law also went to the Supreme Court, and it became known as Ashcroft versus the ACLU. It was argued that it was unconstitutional to require adults to show proper identification in order to practice their right to free speech. The Supreme Court found that minors could be adequately protected from legal pornography by using filtering software. And we go back to Lawrence Lessig's 4 components of control, and code being one of the big ones. So now we jump ahead to 2000, to the Children's Internet Protection Act of 2000. The law requires that libraries and schools who receive government funding to connect to the internet must use filtering software that block obscene images. Librarians objected, and the court case became known as the ALA, or American Library Association, and Minolta Public Library et al. Versus the USA. So this, again, immediately there was a rejection that we have to be controlling speech in any way. The librarians argued that blocking mechanisms will suppress information for adults and that the blocking software is often arbitrary, i.e. a topic such as breast cancer could be blocked and does not block all objectionable content. Additionally, it violates the right of free speech. The Supreme Court supported the Children's Internet Protection Act as long as adults could ask librarians to override the filter if they sought blocked information. Because we all want to go to our librarian and say, take off the filter because I want to look at porn in the middle of the library. And I'm joking, but that's basically what was expected. Because of this law, the burden of protecting children from pornography has shifted to organizations like the schools and libraries, and ultimately parents at home. The American Library Association opposes blocking software. The other question that has been raised is whether children have any constitutional rights. You know, in the sense of looking at the Constitution and seeing if our forefathers, our founding members of the United States, actually cared whether or not children had the same rights as adults. So, blocking software. Code, therefore, has become a substitute for law in regulating the internet today. So rather than passing all kinds of laws, the Supreme Court has essentially said it's up to the software developers to utilize code to ensure that children do not see obscene or pornographic materials. Blocking software is usually set up to look for keywords to block sites. Bots search these sites, so it is rare that real humans are there to examine the sites. And again, you run into issues. For example, back in the late 90s when I was teaching a class on just how to use the internet because people hadn't experienced it, we had blocking software, and the students quickly figured out that if they put words in that were not English but were like, for example, the Russian word for boob or the Spanish word for sex, they could easily access pornography. And as the instructor in the room, it often became a contest to see how much I could teach them before they all got distracted by the pornography. Blocking systems have improved significantly since then, by the way. So, problems with blocking software. Lack of precision can lead to over or under blocking of sites. And again, if you're trying to find out information about breast cancer, testicular cancer, you may not be able to get there. Some blocking software has a political bent, meaning that they are either very, very conservative or very, very liberal. They're not neutral, so it may block sites that discuss homosexuality, addiction, or AIDS, any of the social hot button issues. A conservative site probably would be happy to block. Blocking software can allow the government to block anything they deem unacceptable, such as critical reactions to government decisions, which is done in China and Saudi Arabia. These issues basically tell us that it's a slippery slope. If we start blocking certain things, it opens it up to the government eventually being able to block whatever it wants for the public not to see. In terms of the ethical response to internet regulation, ethicists believe that there are certain criteria that would support responsible control of the internet. The use of these controls should be voluntary. There should be political transparency in the controls. So, for example, companies that don't like birth control should not block sites that discuss birth control in a medical way. And controls should be low level. They should not be adopted by the government because, again, our founding fathers, when they crafted the Constitution, were looking for ways to prevent an authoritarian leader taking over and becoming a dictator. Some companies, such as Apple, have made the decision to self-censor. None of their apps for iPhones or iPads allow pornography. A major issue with mobile devices is also the access of online violent video games. California tried to regulate access to these online games in 2005 by introducing a ban on the sale of certain violent video games to children without parental supervision. In Brown versus Entertainment Merchants Association, U.S. Supreme Court struck down the California law. So again, anything that could potentially infringe on our free speech is usually seen in a very negative light. In a 7-2 decision, the court upheld the lower court's decision and revoked the law, ruling that video games were protected speech under the First Amendment, as are other forms of media. So, for example, you may not find a game like Call of Duty to be appropriate for your 9-year-old, but that's your choice and you have to enforce it. You can't rely on the government or laws to stop your 9-year-old from blowing people's heads off. According to the Supreme Court, video games fall into the same category as books, plays, and movies, as entertainment that communicates ideas and even social messages deserving of First Amendment free speech protection. Also, non-obscene speech cannot be suppressed solely to protect the young from ideas or images that a legislative body thinks is unsuitable for them. In other words, Congress can't decide what's important for your child to not see. You, as the parents, have to decide that. So we're going to move on now to what we call hate speech. And the definition of hate speech is speech that attacks, insults, and demeans whole segments of the population, such as Jews, blacks or African Americans, Arabs, gays, Italians, etc. There are probably more than this, but approximately 7,000 websites that promote hate speech, racism, and anti-Semitism. And they're actually on the rise because, across various different countries, immigration has resulted in a lot of native people feeling like they're being pushed out of the way. And so it's easy to direct their hatred at a group rather than their government. Some of these sites are created by Europeans, but are hosted on American servers because Europe, and especially France and Germany, have had anti-speech laws since World War II. Hate speech is protected under the First Amendment of the U.S. Constitution and reaffirmed by the Supreme Court in 2011 in Snyder versus the Westboro Baptist Church lunatics. And that last part was my own particular perspective. The issue comes down to the fact there's a fine line between hate speech and unpopular political opinion. So these Westboro Baptist Church people would show up at funerals for children and veterans with these horrible signs, basically saying that the child died or the soldier died because we are a sinful nation. We need to repent. And, these people are going through the hardest days of their lives and they have to look at this crap. So a lot of times what you then see is other groups stepping up to prevent the Westboro Baptist people from really getting close to the funeral. A lot of motorcycle groups have done this. Students from various universities have done this. And it's really an awesome thing to watch because they're demonstrating their free speech by blocking the folks with their horrible signs. So now we're going to move on to anonymous speech, which includes software programs such as Tor that enable people to hide their identity online, often to evade surveillance. And Tor is often, again, used in the dark web, piece of the web that's not indexed, that really does engage in a lot of criminal activity, but we'll talk about that later in the term. And what anonymous speech, the necessity of it is very important because these examples represent why we need anonymity sometime when we're on the internet. First, socially sensitive subjects about medical conditions, impotence, depression, and these kinds of things allow you to get on the internet without anyone knowing that you have searched for this stuff. And you would log into your Tor browser and essentially it leaves no digital footprint, which is exactly why a lot of people want to use these Tor software programs. Whistleblowers, people who are coming forward and saying, hey, look, this is not right, my company is doing this, that, or the other thing. It's illegal and it needs to be stopped. Then there's political dissent. And in many countries where you have people who are being subjugated by their leaders, they need the opportunity to be anonymous. And there is actually a group online called Anonymous. They're a group of hackers who like to basically go after the bad guys. And it's one of those convoluted situations where they are bringing down the bad guys, but they're often doing it illegally, which is why they want to hide who they are. It can also be abused. For example, criminals and terrorists can communicate anonymously to plan their activities. And we're going to talk about this in a lot more detail when we talk about the Silk Road and how it became the drug version of eBay back about 10 years ago. It can allow people to communicate inappropriately, such as bullying. It can allow people to libel others. You know, you can say a lot about the president or a famous figure, but if you start libeling people from your private life, that could lead to, a lawsuit. So doing it anonymously is a way that people often do that so they avoid being responsible, and can be used to reveal trade secrets or violate copyright protections. Another big question that we often see come up is, are bloggers journalists? So anyone with a computer or an iPad, cell phone can call themselves a blogger. They can rant and rave about whatever their topic is to their heart's content. But the question is, they claim to be journalists. And this has gotten so significant that it actually went to the courts. And the courts are saying that bloggers are not journalists. They don't follow the fundamental requirements that journalists are supposed to do. Fact-checking, having two sources for information, etc. Some bloggers vow to practice ethical blogging, which involves always telling the truth, checking their sources and identify those sources whenever possible so the readers are fully informed, retract information that is proven false, disclose any conflicts of interest in cases where their objectivity may be questioned. So you may read an article on the internet and at the very bottom it says, disclosure, this website has a parent company that is listed in the article, just because that is considered ethical journalism. There's an interesting issue going on right now. There's a radio host blogger named Alex Jones who runs InfoWars, who has been saying that one of the terrible shootings at Sandy Hook, where 15 or 16 first and second graders were murdered by a nut job, he's saying that it was a hoax and that the people involved were crisis actors, and that this is a way of trying to take away people's guns by setting this up. And the reality of this is that there's a lot of parents who lost their children who are now suing him for libel because he can't prove any of this. He can shout about it, he can write articles, he can do whatever he wants, but he doesn't actually have any proof. So it'll be interesting to see how that plays out in the court system. And finally, we're going to talk about everybody's favorite thing, spam. Not that tasty meat product, but that junk mail that is sent electronically. It costs much less to send than regular junk mail, and the real cost lies in how much time a person devotes to deleting it and how much space it can take up on a server. So spam used to be all the advertisements we got in the mail, and they've come down significantly because we get it all through our email now. And ask your average person how many unread emails they have, and they could have several thousand, because they don't open every time Amazon sends them something. And it may not be considered spam per se, but these advertisements become spam in a sense. True spam would be something like, hey, Russian girls are looking for you for a good time. Or, is your penis too small? Or, free drugs from Canada kind of thing. So, spam is just junk. But we do get a lot of junk mail in general also that's legitimate. In 2004, the federal government enacted CAN-SPAM, Act of 2004. Don't you love how they come up with these names? This act regulates commercial email, and it requires that there is an opt-out mechanism available, identification of the email as an advertisement, and a valid return email and physical address of the sender is available. So, you think it worked out pretty good? Yeah, no, not at all. This act has proven ineffective since spam emails have increased since this act was put in place. There are filters provided by mail servers which control a lot of the spam emails, but now spam is popping up on social media. And in week 1 we discussed how the election hacking was in result to a lot of false news stories that were purchased as advertisements on Facebook especially, but on other social media sites as well. So that's it for today. If you have any questions, please email or text me. If you're not in my class but you still have a question, leave me a comment and I will respond as quickly as I can. Thank you and have a fabulous day.